This installment of Washington Legal Foundation's Legally Brief focuses on the U.S. Supreme Court's recent opinion in Hertz Corporation versus Friend. Justin Florence, who along with three of his colleagues at the law firm O'Melveny & Myers represented Hertz in the High Court, will give you an assessment of the ruling.
On February 23, 2010, the Supreme Court of the United States issued a unanimous decision defining corporate citizenship under the Federal Diversity Statute, 28 U.S.C. Section 1332c1. That statute, which controls the states in which corporations may sue and be sued in federal court, provides that, quote, a corporation shall be deemed to be a citizen of any state by which it has been incorporated and of the state where it has its principal place of business. In Hertz Corporation against Friend, the court held that the phrase principal place of business refers to the place where the corporation's high-level officers direct, control, and coordinate the corporation's activities. This is the location that lower federal courts have called the corporation's nerve center, and it will typically be found at a corporation's headquarters. Prior to the Supreme Court's decision in Hertz, the courts of appeals had applied several different tests to determine where a corporation's principal place of business was located for purposes of the diversity statute. Several courts focused on the corporation's total activities, holding that a corporation was a citizen of and could not obtain federal diversity jurisdiction in the state in which the corporation had the most activity, such as plants, employees, or sales. In this case, the Ninth Circuit had looked to whether the business activities in any one state, quote, substantially predominate, close quote, over other states. Only the Seventh Circuit had applied the nerve center approach that Hertz advocated. The nerve center, the Supreme Court clarified, is normally the place where the corporation maintains its headquarters, provided that the headquarters is the actual center of direction, control, and coordination for the corporation, and not something like a mail drop box, a bare office with a computer, or the location of an annual executive retreat. Under the court's decision in Hertz, therefore, a corporation may invoke federal diversity jurisdiction and remove state court cases filed against it in any state in which the corporation, 1, is not incorporated, and 2, is not truly headquartered. The court pointed to 3 sets of considerations in deciding on the nerve center test. First, the diversity statute's text looks to a single place within a state rather than an aggregation of the total amount of activities conducted across the state. Second, the court observed that administrative simplicity is a major virtue in a jurisdictional statute, and the nerve center test is straightforward. And third, the court reasoned that the legislative history behind the statute supported a simple test. The court's decision may provide significant benefits to businesses. As the court noted, the nerve center test promotes greater predictability, and, quote, predictability is valuable to corporations making business and investment decisions. In addition, by establishing a uniform national rule, the court's decision avoids scenarios in which corporations could be deemed to have their principal place of business in different states, depending on which circuit's test applies. Under the nerve center test, every corporation will have one and only one principal place of business, and it should be clear to all parties where this is.